Okay, this is Rice Hutenga versus Yanni et al., docket number 18-272NH, and this is the time set for hearing on the defendant's motion to strike hearsay testimony and to strike certain expert testimony. And Mr. Van Erp, your motion, you may proceed.
Thank you, Your Honor. I know you've seen the briefs and you know the background this case involves, and a kidney stone presentation that allegedly was not treated timely. The long-term result was a significant infection which required amputations of both feet and portions of all 10 fingers. Economic damage claims are significant in this case. One of those claims involves lost earning capacity. There are two specific arguments regarding earning capacity I'm challenging with this motion. Plaintiff has presented argument and suggested that two career paths were open to her and has presented an expert economist report summarizing the projected lifetime earnings in those two careers. And the economist has indicated that he intends to offer those projections to a jury. I believe both of those projections are highly speculative, and one of them is based on nothing other than hearsay evidence. And I don't believe that plaintiffs should be allowed to argue for either of these career paths. And I don't believe that expert testimony should be presented indicating that the jury should consider the dollar amounts for these two career paths. Ms. Rice Hutenga, at the time of the events at issue, was working as a housekeeper with a Courtyard by Marriott. She previously had worked in a factory setting in a couple of two or three different positions, and she has testified that she was told she might get a housekeeping supervisor's position. The deposition testimony is a little bit scattered, and I had to cite several portions of the deposition. But if you piece plaintiff's deposition together, she lived in Onondaga from about 2003 to 2012. While she was in Onondaga, at one period she worked for GM, actually a couple of different periods. She was a temp for a little bit and then worked for a couple of years. She testified that GM let her go because she was off work because of her back, and the paperwork, according to her, never came through. But then she also testified that GM had found she had a pre-existing problem with degenerative disc disease, and that was the reason she lost the GM job. She then did some schooling in between and worked at another small factory in the Onondaga area. After she moved to Mason, Michigan in 2015, she worked for a little while at a factory, and then she's testified that she left that job because it wasn't the type of work she wanted to do. She preferred housekeeping. And at the time of the events in question, she was working as a housekeeper. So I'm arguing as to factory work, and in particular, factory work based on the GM wage, which the expert has presented. That is an entirely speculative claim that, according to plaintiff's economist, is worth a lifetime of about over $3.5 million in earnings. Significant number to put in front of a jury when there's nothing other than a remote history of working at GM and losing that job by her own testimony because of a degenerative back problem. Regarding the housekeeping supervision position, which the economist has valued at about $2.5 million, well over $1 million more than she would have made in a housekeeper's position. The sole basis for this is that plaintiff has testified that a supervisor at the Marriott, who she could not name, said that she was going to get a housekeeping supervisor's job. That testimony is clearly hearsay, and there's been no indication that there's any legitimate testimony confirming this position that will be offered. that position therefore also strikes me as speculative. So again, I don't believe the claim should be made, the argument should be made at all. And I certainly don't believe that an expert should be allowed to opine that this was an option and here's the $1.5 million that she would have made had she gotten that position. As far as the law goes, I think I've covered it pretty well. The law that requires damages to be shown with reasonable certainty and prohibits speculative damages. I note that plaintiff's response tries to draw a distinction between speculative and, quote, purely speculative, close quote. From that, I think that plaintiff is attempting to argue that unless it is 100% speculation, if there's any remote factual basis whatsoever, they can make the claim. I think the case law I've given you is more controlling and provides a more realistic description. And the case law that I've cited for you essentially requires proving damages with reasonable certainty. So I think that plaintiff has to meet that reasonable certainty standard and does not have evidence to meet the reasonable certainty standard. I'm therefore asking that first, plaintiff be precluded from arguing either of those career paths, excuse me. And second, that plaintiff be prohibited from presenting any expert testimony as to the likelihood that those jobs would be an option and as to the dollar amounts that those jobs could have resulted in. Unless you have any questions, I'm all set.
I do not. Thank you. Mr. Carley?
Yes, Jennifer, thank you. I think a couple things are being confused here by the defendants in this case. First of all, the damages allowed in a situation like this are lost earning capacity, not lost wages. As we pointed out in our brief, there's the Miller versus Pillow case from the Michigan Supreme Court in 1953, which set forth, and it's still good law today, damages should be estimated on the injured person's ability to earn money rather than what he actually earned before the injury. And the difference in the actual earnings of the plaintiff before and after the injury does not constitute the measure. Hence, the amount which plaintiff is capable of earning and not which he was actually, or not which he has actually earned, since the injury is to be taken into consideration. Then they conclude with saying, accordingly, recovery may be had for impairment or diminution in earning ability or power, even though it should not be shown the plaintiff has in the past earned anything or been engaged in remunerative or compensable pursuits. Well, in this case, we've actually gone one further. We know that she did do the factory work at one time. They're trying to say the reason she couldn't do the GM work was because of this degenerative back disease, which many laborers and people in general have, and doesn't mean it's debilitating. Here, apparently, she was off work for some time. There was confusion about the paper, about papers, she said, and therefore she was let go. I think it's important to note that even after she was let go from the GM job, that she worked in a factory after that. So obviously, I think what they're trying to say is she can't do this job because of a back issue, but there's been no actually testimony in this case whatsoever that the back issue precluded her from doing any job, or would preclude her from doing the job in the future. There's no disability here. She wasn't on disability for back or anything. And she went on to testify that, she actually went to work and was working as a housekeeper in a hotel motel situation, which is pretty strenuous work in and of itself. So I think they've sort of, looked at this incorrectly when it comes to lost earning capacity. Speculative damages, all future damages are speculative to some degree, but here we know she worked as a factory worker. Here we know she was working as a housekeeper, and here we know that she was told that she she would or could be working in a supervising capacity at some point. I don't think that's hearsay, because we're not using this testimony to demonstrate what she would have done. It's what she could have done. And certainly you take into consideration a person who is at her age, who is working, you have to take in consideration promotions. It's like saying someone who was an attorney who can no longer be an attorney, but he was a third-year attorney, was not going to make any more money the rest of his career because because of the fact that what he was making as a third-year attorney. And this is exactly what Miller versus Pillow in the Supreme Court was saying. Again, I don't think it's hearsay at all, because it was just being shown to prove what she could do, not what she would do. That's all up for the jury to decide in this case. And actually, I think we went farther in this case by only doing the 3, as opposed to if she had actually gone back to school and done more, what she could have done with regard to that. I think it's more realistic in this case. The expert testimony they're talking about is Mr. Thompson's testimony, who's our economist. He merely puts numbers on this. It's the jury who decides what she would have done or could have done in the future based upon her testimony at trial and the proofs and evidence at trial. So I think the motion should be denied. I don't think this is purely speculation based on the fact that she did do factory work. She was doing the housekeeping work, and she very well could have gotten promotions in the future under that job. Was actually told that was a possibility. I think that's pretty much all I have, unless you have any questions, Your Honor.
No, I don't believe I do. I'll let Mr. Vanner give rebuttal if he'd like.
Just a couple of comments. Number one, there is certainly an element of hearsay in terms of the statement that a supervisor said she'd get promoted. And that bit alone, at least, I think needs to be excluded, because it's clearly hearsay, and allowing plaintiff to say someone told me I'd get promoted without a backing or a source for that is, I believe, impermissible speculation. And then as far as the earning capacity versus earnings history, Mr. Carley is correct in stating that earning capacity is recoverable, but all of the case law still requires that there be some reasonable certainty. We can't just say someone's earning capacity is essentially unlimited and we can tell a jury to give them anything we want. And more importantly, we don't allow an expert to come in and say, here's the millions of dollars that would have been earned from this position, when there's not some credible evidence that a person was reasonably likely to wind up holding that position. And that's all I have, unless you have questions.
I do not, thank you. So I do think it's important to draw the distinction that the plaintiff has drawn, and even that the defendant acknowledges, and this is about earning capacity and not lost wages. And what the defendant is challenging here is the proposed expert's opinion regarding 2 different career paths that he based his opinion on that the plaintiff could have pursued. And one was not just hotel housekeeping, but being a hotel housekeeping supervisor, and the other was being a factory worker. And the issue here, the defendant doesn't challenge plaintiff's work as a hotel housekeeper. The issue is whether there's some reasonable likelihood that she could have been a hotel housekeeping supervisor or a factory worker that the expert could then base his opinion on. And it is about lost earning capacity and not about lost wages. And for that reason, the damages here aren't comparable to a business's lost profit damages, as the defendant has cited in their brief, because people don't always operate as businesses. I say not always. I always do like to say businesses are people too, but people don't always operate like businesses, and not in this context. Lost earning capacity takes into account people's abilities and their aspirations, and whether those are realistic, which is for the jury to decide. That was the exact problem in the other case the defendant cited, Craig, C-R-A-I-G, versus Oakwood Hospital, where Dr. Ansell, A-N-C-E-L-L, didn't consider whether the plaintiff would gain employment in a particular area, or that she even wanted to pursue a particular career path. So the Court of Appeals there said that, therefore there was no basis for his testimony about lost earning capacity. But they give us, you know, clues there as to what we might look at. And here we have the exact opposite situation where the plaintiff actually was working in hotel housekeeping at the time of the events that are at issue here. And she did aspire to a supervisory position. And in that regard, her statement that she wanted to progress to supervisor is certainly admissible and it's relevant, and it provides a reasonable likelihood that the proposed expert testimony here could be based on about her lost earning capacity as a hotel housekeeping supervisor. There's also the statement that counsel has referred to where someone, she can't remember who, told her that she had the opportunity to advance into a supervisory position. Now, you can't just say that because someone else said it is hearsay. Obviously, there's multiple exceptions and exclusions to the hearsay rule, and you always have to look at context. But in this context, someone telling her that she had the opportunity goes to her state of mind. It says in this context, it says something about the legitimacy of her aspirations or the legitimacy of her goal. Why would she think that she could go into hotel housekeeping supervisory position? Well, because she had been given indications that she could, not just that she aspired to it. She could have aspired to be a rocket scientist, but that her aspirations were based on her state of mind, her goals, her aspirations were based on something that someone had said to her. So I don't think in this context that is hearsay. And I can certainly give the jury a limiting instruction that tells them the proper use to be made of that testimony, and that it does, that it is used to show the plaintiff's state of mind and not to prove the truth of the matter asserted. So I do not think that the testimony overall in this case fails to present a reasonable likelihood of career advancement in hotel housekeeping supervisory position such that the expert could not give testimony about that in the future for the plaintiff had she not suffered this situation here. The issue about factory work in the future is also not speculative and does present a reasonable likelihood based on the testimony in this case. So the previous position that she had was in a factory, and she did testify in her deposition that she was let go, but she said it was because the paperwork didn't come through. She was off work at the time, and but nowhere in the testimony that the defendant pointed to did she ever say that she couldn't do the factory work for any long-term period of time. She said she was let go because she was off and she didn't get the paperwork in like she was supposed to. And then she did say that she had degenerative disc disease, but she never said that that prevented her from ever working in a factory again. And even more important than that, she did work in a factory again. She did that work after the job where she was let go, and as I understand it from her testimony, immediately before she began her hotel housekeeping work. So there's no issue with regard to this degenerative disc disease and being let go from the previous job, because she actually had a history since then of factory work. And then the defendant also argues, well, she preferred hotel housekeeping to the factory work. Well, that is true. She did say that. She said she left that other factory work because she preferred hotel housekeeping. But that doesn't make it speculative that having done that work in the past, she would never, having preferred hotel housekeeping, she would never have the capacity or desire to ever do factory work again. There's nothing to say that she couldn't return to factory work in the future. So just because she preferred hotel housekeeping work doesn't rule out factory work, and it does not rule out the expert's testimony. In other words, the evidence in this case thus far represents a reasonable likelihood that that would be a career path that she could have also chosen. So for those reasons, I am denying the defendant's motion to strike the hearsay testimony and to strike the expert witness testimony. And
Shall
do
I
you want
send-
to-
Shall I submit a brief order denied for the reasons stated on the record?
Sure, if you would
Your Honor-
please.
Yeah, I was going to ask you too, Your Honor. I don't think we've done that, but I will do that about last week's summary disposition motion. Just say it's denied for the reasons stated on the record.
Yes, we might have forgotten to get to that last week, but we should do
Yeah.
that too.
Right.
All
I will do-
thank
Okay,
you very much.
thank you, Your Honor.
Thank you. Good day.